So there's no legitimate interest or governmental interest under those circumstances, and hence violates the equal protection and due process rights of my client.
Oh, this is interesting. Okay. We are on the record. Oh, everybody, go ahead and be seated. We're on the record in case A844652, Anna Marie Echevarria versus Zaon Collins. We are here to discuss jury instructions and verdict forms. We are outside the presence of the jury. Can I, counsel, just go ahead and make a record of their presence?
Ramzy Ladah for plaintiff.
Joseph Chu for the plaintiff.
Stephanie Zinna for defendant Marvin Collins.
Brad Johnson, on behalf of Marvin Collins.
Okay, so I hope I looked at the right set. I looked at the set that was filed on April 25th, 2025. I compared it to the notes I got from Ms. Zinna, which of course are not handy to me right now, but
I have a copy, Your Honor, if you want.
I think I wrote on the copy I had, so let me just try to locate it.
Okay.
But thank you. Because this is the set that you went through too as well, right? As I understood it by your comments.
So my chart included ones we had already stipulated to, just with the notations if there were typos, and then my response to the ones that were originally disputed as to whether or not I would maintain my objection or stipulate.
Okay, so everybody has the 425, and by 425, I mean it was filed on 4/25/25 at 8:39 p.m.
Yes.
Everyone has that set in front of them to use the controlling set, right? I just want to make sure we're all
Yes.
operating from the same original set.
Yes, Your
Yes,
Honor.
Your Honor.
Okay, so let's go through that. So as I went through it, it was my understanding, no objection to the first one. No objections and no issues until we get to page 11, which is Nevada jury instruction 1.12. I agree that this is not needed because I think we've read it enough, but I'm happy to add this. I just don't know if this should be added at the end.
That's fine, Your Honor. I don't have a strong feeling on it.
So no one has a problem if this one is pulled out, right?
No problem, Your Honor.
Okay. Defense counsel too, I think you're the one.
Correct, yeah, that was my note. I don't believe it's
Okay.
needed.
So that will be.
Join, Your Honor.
Well, I didn't get anything from you, Mr. Johnson, right? You didn't file anything, right?
Correct. I'm just
Okay,
going.
just want to make sure I wasn't missing something. Okay, so
Thank
the
you.
next issue is page 13, Nevada jury instruction 2.14. Defense has said this is not needed. I do tend to agree unless something is anticipated to come up. Who do we have left? We have the detective, and then who is after the detective?
It's our economist expert.
The economist,
And then-
okay,
and then the
and
parties.
then, what'd you say?
And then the parties.
And then the
plaintiffs.
parties, and then you're gonna put, okay, so was there any? Does anybody anticipate this coming up? I generally leave this till the absolute end, just in case somebody asks, well, did you talk to the attorney before today? Which I don't recall if that was asked of any of the current witnesses.
It wasn't.
I don't think it has been, Your Honor.
Do you guys wanna leave it just in case, or are you pretty confident that it's not gonna be asked? Cause if you're pretty confident, I'm just gonna mark it as out right now.
If it doesn't come up, Your Honor, we're fine with taking it out. But
Okay.
if it does come up, we're gonna request it.
Okay, so why don't we leave it in then if there's a possibility? So I'm just gonna put tentative out on my notes, depending on what happens next. Or what happens with the remainder of the trial. Bless you. Okay, the next one with an issue, I believe, is page 22, 1101. It's your duties as jurors to consult with one another, and I had an issue with this one just because I think the order is weird. So I think this is staying in, but I anticipate we're gonna put this at a different place in the order of these instructions. Anybody have any problem with that?
I do not.
There's a few that I've got an order issue with that once we get the final set agreed to, I'm probably gonna put them in a different location just because I don't think this makes sense to necessarily put in the middle of the instructions.
Sorry, I thought 22 was stipulated.
It is stipulated. I'm telling you though that I'm probably gonna change where it is in the order of instructions, and I just want to find out if there's any problem with that.
I understand now. Your Honor.
Okay. I'll change that at the end once we do have the final set. 23, same thing. It's jury instruction 1.14. I anticipate probably putting this at a different place. Any objection to putting this in a different place once we've got the final set agreed to?
No, Your Honor.
Okay. And then the next one with an issue. Oh, page 27, 1.13, the purpose of the trial is to ascertain the truth. Guys, number one, my question was, do you guys really want this in? And number two, you really want this in this location? Because again, this order is a little bit weird to stick this kind of in the middle.
I don't, quite frankly, I don't care one way or another if it's in there. I don't think it's necessary, but if it's something that plaintiff really desires, I don't have an objection either, but I agree with Your Honor about the order. It needs to be towards the beginning.
We are requesting this instruction, Your Honor, but I'm fine with it being at the beginning and changing the order.
Okay, this will be closer to the beginning then. So I'm just marking it as an order once we get the final set agreed to. Okay. The next one, page 28, 1.11. Okay, so I had a couple of questions. You really want this in the final instructions? Now, I'm happy reading this if we're gonna break for the weekend. And like if we read them, break for the weekend, and then you come in and do your closing. But I don't think you need this. I think it actually can be a little bit confusing. Some parts anyway, if we read this right before they go to deliberate. So I'm gonna tentatively leave it in. If we read it before, like if I read these on Friday and then they go for the weekend and they have closing arguments on Monday, I'm happy to include it. But if I read these on Monday, I think if we do put this in here, we need to modify it.
In my
Where-
position, I'm sorry,
ahead.
go ahead. Okay, go.
I was just gonna say I'm fine taking this out, Your Honor.
I am too. I missed it. I apologize.
Okay, so everybody's fine with this one being out.
Yes, Your Honor.
Okay, because I think that, look, I think number two is great to read them before they go to deliberation, but number one is really confusing when you're going to give it to them to deliberate. So, but this one is out then by agreement?
Yes, Your Honor.
Yes, Your Honor.
Okay. Okay, the next one, the problem was, and the next one as in, I'm talking about 1.15, page 29. I tend to give this and not 11.02 because the readbacks are really confusing. So as we're looking at this, let's look at it compared with 11.02, and I'm sorry, I don't know what page 11.02 is.
34.
Thank you. So I tend to not give 11.02 because it has the extra paragraph about the readbacks. And I don't want to encourage that, but I think it is important that they're able to ask a question if they want to ask a question and that they understand how to do it. So does anybody have a strong preference to giving 11.02? And if so, let's talk about it. Otherwise, I'm just going to give 1.15 and 11.02 is going to be out.
Plaintiff is fine with 1.15 and not 11.02.
Defense?
Go ahead, Your Honor.
Okay, so we'll keep 1.15. And out. Okay. Next one with an issue. If I'm correct, and if I miss any, let me know. Page 32, 2.10. Before a trial, each party has a right to ask another party to admit in writing. Will this apply? Because I know defendants said they're fine with it coming out. But is anybody thinking they're gonna ask the remaining witnesses about RFAs?
I don't believe so, Your Honor. I'm fine taking it out.
Okay, so this is out by agreement. Okay, this next one, 2.13, page 33. I don't have a problem with, I believe you guys didn't have a problem with, but I want to make a slight amendment to it. I want to say the lawyers and or witnesses have shown you charts and summaries to help explain the facts and may show you more in closing arguments. So I want to add that language because I imagine that you haven't shown all the charts and summaries that you were going to show yet. The charts and summaries, and then the rest stays the same. The charts and or summaries themselves, however, are not evidence or proof of any facts. Charts and summaries are only as good as the underlying evidence that supports them. You should therefore give them only such weight as you think the underlying evidence deserves. Anybody have a problem with me adding the 1, 2, 3, 4, 5, 6, like 7 words at the end or as a part of that first sentence? So the 7 words would be and may show you more in closing arguments.
No objection for plaintiff, Your Honor.
Objection. Because the only chart I think we've seen so far is that chart that came off of the black box information, right?
Correct.
Okay, so I'll make that change and that will stay in. The next one we already talked about was out. The next ones we have are the, they were submitted as additional, but many of them are stipulated too. So I'm gonna skip over the ones I are stipulated to, or do you want me to quickly say what I believe is stipulated to, just to make sure I'm not missing any objections?
I think we should just make sure.
Okay, so 2.11, the fact that a witness has been convicted of a felony, it's my understanding that's stipulated to.
Correct, Your Honor. Under the facts of this case, it is an appropriate instruction.
Okay, so that will stay in. Okay, the next one. Plaintiff seeks to, or 4.1, plaintiff seeks to establish a claim of negligence against defendants Zaon Collins, which that should be singular. Plaintiff seeks to establish a claim of negligent entrustment against defendant Marvin Collins. Oh, now instructed in law. It's my understanding this one is stipulated to as well, right?
I'm sorry, I didn't catch this, Your Honor, because of the NRS 41.440. If the court grants the instruction, I think this should be changed to plaintiff seeks to establish a claim under NRS 41.440, because we would be dismissing our negligent entrustment claim if the court grants our directed verdict on NRS 41.440. And I talked to Mr. Johnson this morning about that. I don't want to put words in his mouth, but my understanding was he wasn't disputing the facts, or that the facts, as a matter of law, invoke the statute. His only objection would be he would be reserving his right to appeal NRS 41.440 under a constitutionality argument. Did I say that correctly, Brad?
Yes, Your Honor. My understanding that at least up until very recently, this case was based upon claims against my client, Marvin Collins, were negligent entrustment. They haven't proven that claim. The directed verdict on that. Now it's shifted, or at least it's more nuanced to more of the family purpose 41.440, which is a vicarious liability statute. The court is well aware.
Okay.
I agree that they've established that it was my client's car and that his son was driving it and that the son was going to basketball practice. My position, I can make a record on it whenever the court would like, that it is that particular statute is unconstitutional.
That NRS 4.0.
Or zero.
Okay,
Yeah.
you think it's unconstitutional?
Yes, Your Honor, and I can make that record now if you would like.
And you want me to declare it unconstitutional?
I'm gonna make the record, Your Honor.
I'm just asking if that's the relief you're asking.
That
me to
is
give
the
you.
relief I'm asking, Your Honor.
Okay.
So it goes hand in hand.
Okay, this definitely needs to be briefed. Did you brief this?
Your Honor, I have not briefed it. It's a fairly straightforward,
Okay.
um,
Unconstitutional, why?
well,
Because it's fairly straightforward. Tell me how it's so straightforward.
sure.
I'm
Your
not
Honor,
mocking you, by the way. I'm smiling, but I'm not mocking.
I know, I understand, Your Honor. I get a lot of that. 41.440 is unconstitutional as it discriminates against a suspect class. We've had cases, Arata versus Fabian, Faubion, 123 Nevada, 153, 2007, which specifically addressed whether or not NRS 41.440 was constitutional. And
Yeah,
based upon that analysis, the Nevada Supreme Court found that it was. However, in this
that it was
particular,
constitutional.
that it was constitutional. But the analysis is different than in our case, because it's our position that and it was not argued or presented in that case, that it discriminates against a suspect class. In that particular case, Supreme Court said this wasn't a suspect class situation, and therefore its analysis was under a different standard. In this case, it just disproportionately impacts minorities generally, and African Americans specifically, as they are much more likely, due to historically documented economic disadvantages, to share a vehicle with family members who cannot afford separately owned cars. And the fact that in this particular case as well, the Nevada statute mandating bodily injury insurance coverage for the shared car does not meet the intended purpose, according to that particular case, to encourage owners to use greater care in allowing, quote, financially irresponsible, close quote, drivers to use their vehicles. So in this particular case is when they were making that analysis is you can't have your car and then have, somebody who has no money to meet a potential judgment in an automobile accident. Well, that doesn't even apply here because you only had to have the mandatory amounts. And in the particular facts in this case, which have been borne out, ironically, I think Zaon is in a better financial position to meet a potential adverse verdict in this case than Marvin, who is a 61-year-old disabled father. So there's no legitimate interest or governmental interest under those circumstances, and hence violates the equal protection and due process rights of my client.
Oh, this is interesting. Okay. Any response?
Your Honor, I believe the Nevada Supreme Court has already declared this constitutional. I just want to say that we did allege this originally. It was in the amended complaint at paragraph 13. I'm reading right off the amended complaint. It says, upon information and belief.
Wait a second.
Sorry.
I didn't hear you making the argument that this wasn't previously alleged or that you weren't on notice of this potential claim, right? Did you make that argument? Did you say that?
I'm sorry, I could say.
I didn't hear you making an argument that 41.440 was not previously alleged or that you weren't on any notice that this was potentially going to be brought against your client.
Your Honor,
And
I'd like to be perfectly honest, as it was unclear to me, because when we reviewed the jury instructions, it wasn't in the jury instructions. It was strictly a negligent entrustment. And whereas the complaint technically would put us on notice that they were going to bring that claim, those claims can come and go willy-nilly. But in this particular case, it was clearly a negligent entrustment case because it related to the speeding tickets and what we addressed in opening. It was only after that negligent entrustment case more or less fell to the wayside that we shifted to the family purpose or the 41.440. So I don't know if that answers your question or not.
what's the date of your amended complaint?
It is
The file date.
11/2/2023. And when you're there, I'll take you.
Okay, yes, tell me where you're reading.
Paragraph 13 on page 3.
On information and belief, defendant Zaon Collins was an immediate family member of defendant Marvin Collins under NRS 41.440 and therefore vicariously liable. Okay, so this was in the amended complaint filed on November 2nd, 2023. Okay. As for the so your suspect class is you're saying that minorities are adversely affected by 41.440?
I'm saying minorities, generally, certain minorities would not fall into that,
Okay,
but
Maybe
specifically
socio-
African Americans, which my client is, they are adversely impacted by that because they're much more likely to be in a position whereby they have to share cars based on their economic disadvantages.
okay. I'll let you make this, but I need you to brief it. And we can actually hear this. Rather than just orally present it, because you're making a pretty, if you're asking me to declare something unconstitutional, you need to have a record, especially if you, well, number one, if you think you have a chance of me granting it, I'm sure they want a record just in case they want to bring it up. And if you think there's a possibility I'm gonna deny this, you might want your record so that you can do whatever you want to do. Because I assume you're gonna think I'm wrong if I deny it, right?
Your Honor, I would never think that a judge is wrong, may disagree, but I appreciate the opportunity to brief it.
Okay, so yeah, how quickly can you get a brief?
Tomorrow.
If he gets a brief tomorrow, how quick you guys think you can respond?
I'll be honest, I don't know, Your Honor. I mean, this is,
Okay, we'll see his brief and then we'll talk about it tomorrow.
okay.
Okay,
The brief will be brief.
understood. Okay,
The point is, I mean, if Your Honor does not declare it unconstitutional, I would be dismissing my negligent entrustment claim. And therefore, the only claim against Marvin Collins would be under NRS 41.440. And therefore, the instructions would need to change to take out and replace any place where it says negligent entrustment to under NRS 41.440.
oh, so you are dismissing your negligent entrustment claim?
As long as Your Honor does not declare the statute unconstitutional, yes.
Okay. Okay, so for now, let's just put a pin in this instruction then.
Okay.
Okay, so I'm gonna note that we need to revisit. Let me put a different color post-it on it.
Sorry, which number was that?
Page 38. It's Nevada jury instruction 4.1. So we need to revisit after I get briefing from Mr. Johnson. Yeah. Okay. But otherwise, defendant stipulates to this, right?
As it pertains to Zaon Collins, yes, plaintiff seeks to establish a claim of negligence against, it just needs to be a singular defendant, Zaon Collins. I will now instruct on the law relating to these claims. That language as it applies to Zaon is fine.
And if I don't dismiss, or if I don't declare 41.440 unconstitutional, Mr. Ladah, you want negligent entrustment to be revised here to say, seeks to establish a claim of vicarious liability pursuant to the family purpose doctrine?
I would like to actually say the statute, under NRS 41.440, and I have another proposed instruction where I propose actually telling the jury what the statute says.
Okay, I did see that one, so we'll kind of put these all in the same category for now. Okay. Mr. Johnson, do you want to make any more comments as to this one, other than what you've already said?
No, Your Honor, thank you.
Okay, the next one, it's Nevada Jury Instruction 4.3, page 39. Generally, everyone has a duty to exercise reasonable care when their conduct creates a risk of physical harm. It's my understanding defendant stipulates to this, correct?
I'm sorry, Your Honor, which page?
39.
39, yes.
Okay, so if defendant stipulates to this one's in, right?
Yes, Your Honor.
Yes, Your Honor.
The next one, page 40, Nevada Jury Instruction 2.1, plaintiff is seeking damages based upon a claim of negligence and negligence per se. It is my understanding defendant stipulates this one as well,
It's
correct?
gonna be another instruction, Your Honor, that's going to depend on the ruling. Because plaintiff this morning submitted new instructions that change that language that we just discussed, so if we could just flag this one.
Okay.
So this one correlates with page 6 of defendant plaintiff's filing this morning with their proposed changes.
Okay, and that was filed today, 5/14, right?
Correct.
Okay, so I'll tag that one as it needs to be revisited compared to that one. Okay, the next one, page 41, Nevada jury instruction 4 NG3, the preponderance or weight of evidence is not necessarily increased with a greater number of witnesses. It's my understanding there's a stipulation to this, right?
I have no problem with this one.
Are you guys following the same set I'm following?
Yes, I am.
Go, Judge.
I just had to get to it. I'm sorry, Your Honor.
That's okay, I just want to make sure we're all on the same page.
No objection to this.
No problem with this one, so this one's in by stipulation. Okay, the next one. To my understanding, the next one is Nevada jury instruction 4.9 from the 2018 set. Defendant claims the negligence of plaintiff's decedent, contribute to his or her death. To succeed on this claim, the defendant must prove both of the following. The plaintiff's decedent was negligent, and the negligence of plaintiff's decedent was approximate cause of his or her death. It's my understanding defendant stipulates to this, right?
Correct, but I
With the
proposed
typos.
I proposed an instruction on page 10 of my submission. Just correcting some of the pluralities and his, hers.
Any problem with her corrected version besides one other thing that I'm gonna bring up in a minute?
No, and I want to thank her for correcting any typos or pluralities.
No problem.
Okay, so here's what I'm gonna bring up. Throughout this, I believe you guys are saying proximate cause, right?
Yes, Your Honor.
Yes.
Have you guys reviewed the use notes on proximate cause and legal cause? And I'm talking about the use notes, or the use note on proximate cause from page 64 of the new set, 4.4 and 4.5, where it actually talks about when we should be using legal and when we should be using proximate. And in light of that use note and what I believe is being alleged here, are you all still stipulating or in agreement that we should be using the proximate cause instruction and saying proximate throughout, not legal?
Plaintiff is of the position that it should be proximate, not legal. I realize there's a little bit of confusion in the law as to the changeability or lack thereof of the two, but our position is proximate cause is the right instruction, Your Honor.
You guys want to take a minute, read the use note? Do you know what I'm talking about?
I do know what you're talking about. I
Yeah,
have
pull up the
not.
2018. I'm gonna read from the use note, and this is where like I was a little surprised that you guys had proximate everywhere. So the use note on proximate cause says the proximate cause instruction is frequently replaced by a legal cause instruction. It cites the DeBoer case. If we keep going, I'm gonna read the relevant part here. A substantial factor causation instruction is appropriate when an injury may have had two causes, either of which operating alone would have been sufficient to cause the injury. However, a footnote in Wyeth states, we leave open the issue of whether the substantial factor instruction applies in negligent cases. It keeps going on. California no longer uses the proximate cause instruction in any case. Johnson v. Edgar points out that the but-for instruction should be abandoned in favor of the substantial factor instruction in cases in which an injury may have had two causes, either of which operating alone would have been sufficient to cause the injury. And maybe the allegation here is not that. And then we read, if you look at the source authority listed on 4.5, which is the legal cause. If we go down to the last couple sentences, a substantial factor causation instruction is appropriate when injury may have had two causes, either of which operating alone would have been sufficient to cause the injury, cites Johnson. points out that the but-for instruction should be abandoned in favor of the substantial factor instruction in cases in which an injury may have had two causes, either of which operating alone would have been sufficient to cause the injury. Now, maybe the allegation here is not that either of which operating alone would have been sufficient to cause the injury. If council are in agreement that proximate is appropriate here, we will leave proximate, but I just want to make sure you've reviewed the use notes and the authority citations and confirm that that's what you think is appropriate based on what's being alleged, because I might not 100% understand what you guys are going to argue in your closing yet either.
And I appreciate the court pointing that out, and, on. this
And I only
discussion,
read
I think
excerpts
you're
from
correct,
those.
Your Honor. I think it should probably, I don't,
Your Honor, if I may, I don't mean to interrupt this, is that I didn't want the proximate wording in there. It's confusing.
Okay, well, here's where I'll, if you actually, the source authority on the legal cause, if we read about, I don't know, a couple sentences or a couple lines down, where we start talking about two theories. The two theories were presented as mutually exclusive, and the cause of the plaintiff's injuries could only be the result of one of those theories, but not both. Isn't that what we're saying? Are we gonna have two different theories presented with the cause only being one of your theories? And if so, does that not mean that legal cause is the appropriate one? Why don't you guys both review those and we'll revisit this before we read them on Friday, maybe? And if anybody needs what I'm talking about, I have copies. I'm happy to give you copies.
Thank you, Your Honor.
Okay.
I have a problem.
For now, this one is in with the corrections. We're gonna leave proximate cause for the moment. But if we revisit and decide that legal cause is the more appropriate one, then we'll revise that. The next one, page 43, to prevail on a claim of negligent entrustment. It's my understanding that, well, this one, if, depending on my ruling on this one, you're gonna want that out anyway, right?
Correct, Your Honor. We don't need, we're gonna dismiss negligent entrustment if the court
Okay,
grants our motion on, or does not declare NRS 41.440 unconstitutional.
okay.
Your Honor, now all of us reserve our objections on negligent entrustment. I don't think it's the proper instruction, but
Oh, you don't think this is a proper instruction on negligent entrustment?
they're leaving out. If we've got a standard jury instruction, a stock, I'd be fine with it, but this is a quote out of a case. There has to be additional languages on this, on the negligent entrustment. Just entrusted his vehicle to another person and the entrustment of the vehicle was negligent. There's case law that states that there has to be known or should have known that this individual was somehow incompetent or should not be. There has to be, my client has to have some sort of knowledge of that. and
Okay,
that's
well, if
not
you
in
think this is gonna stay in, then I do need an alternate suggestion from you.
For what
Now,
it's worth, there is no pattern instruction on negligent entrustment.
probably you have to pull from, I bet you, the NRS.
Yeah.
Is that,
Uh,
but I think the NRS actually might be worded pretty close to entrustment his or her vehicle to another person and the entrustment of that vehicle was negligent. I think the NRS might actually be pretty close to this wording.
I believe it's primarily defined just in the case law, Judge. We'll confirm though.
Okay,
Thank you. Thank you,
Okay.
Counsel.
the next one, page 44, 4.10, every person has a right to expect that every other person will use reasonable care. I don't think there's a problem with this one. I think that this one was stipulated. The only problem is I think that this is duplicative of another one, isn't it?
Sorry, where are we, Your Honor?
Oh, page 44,
Okay, got it.
Nevada Jury
Thank you.
Instruction 4.10, every person has a right to expect that every other person will use reasonable care and will not violate the law. I thought that this was duplicative of another instruction.
It is at page 57. It's literally, I was just, I think, included by accident because it's literally the same.
Okay. Well, there's a couple of wording differences, so do you guys want to
This
look
is
at
the
both?
difference. The difference is the bracketed language versus whether it's in or out. That's the difference. So one of mine that I proposed, they are duplicates of the NRS or the pattern 4.10, but one set has the bracketed, one set does not.
The bracketed language, judges, are the words there's two sets of bracketed language. The first is before the first comma in brackets and will not violate the law. And then before the period at the end of the sentence, bracketed language or will violate the law.
Okay, so I guess my question to you guys is, do you guys stipulate to one or the other of these? And if so, which one? And if you don't, what are people's positions with either one and why?
Our request is the bracketed language. We think it's more thorough and appropriate.
The longer one.
Yes.
You want the longer one. Any
Yes.
problem with the longer one from your end? And by that, I mean, I guess I should say, does defense have any problem with the longer one?
I do.
I mean, you're both claiming that there was a violation of the law, right? As I understand the theories of the case.
Correct.
So the longer one is probably the appropriate one. But if you guys both stipulate to the shorter one, I'll put the shorter one in, but it doesn't sound like there's gonna be stipulation, but I'm telling you right now, I'm probably gonna lean toward the longer one because of some of the other ones in here. I saw that you guys did put the left turn law in here. I think you guys did put the speeding law in here. I know there's some objections to some of those, but I thought the left turn one, there was no objection to.
Okay, Your Honor, I'll reserve the objection, but I understand the role.
Oh, okay, okay, well, the longer one's in, okay, this longer one is in, 44 is in, and page 57 then is going to be out. So if we keep going, page 45, about jury instruction 4.13. I thought there was stipulation too. But is there not? Am I misunderstanding
So
something?
here's my position on this. So this one at page 45 and the next one at page 46. Were the rules of the road laws that plaintiff wanted to include. And my issue was, I think that 45 is an accurate statement of 484B.600. Which I don't have a problem with. The problem I have with the 484B.653 is that that's the reckless driving statute that provides a basis for criminal prosecution and requires a different burden of proof, which we're not here to decide.
But this is negligence per se, right? So they're saying negligent because he violated this. What did he plead to?
He
Which
pled
one
to
is-
reckless driving. So they have that, they can use that and
Is
they.
reckless driving 484B.600? I'm sorry, I don't know the MRS by
Yes,
heart.
it is. That's the statute.
Is that your understanding too, that this is that the first one, what's on page 45 is what he pled to?
I believe so, Your Honor. I can check just to confirm. Let me pull up the commissions, just make sure. All right.
But my position is, while he was convicted of that, we've already touched upon that, they have the judgment of conviction on that.
Well, he's admitted to violating this, right?
Instructing that the jury can find that he's done this in this case, right? This is, again, the criminal statute, it requires the different burden of proof. So it's the beyond a reasonable doubt standard that would be used to decide culpability under this statute. So I think if we're going to include any reference to, I would object to any reference to 484B.653 because I think they have the judgment of conviction in and they can talk about it. But it needs to state that he was convicted of reckless driving, which is defined as opposed to asking this jury to meet that higher burden of proof. It doesn't make sense for this jury to evaluate whether or not he broke the law under a different burden of proof.
Well, okay, he's admitted to violating this law,
Correct.
right? So, it's not an if you find, there should be a sentence at the end saying that he admitted to violating this. Like there's essentially
So the end
admission.
of this paragraph says, if you find that the party violated the law, and that's the problem there.
Yeah, this needs to be revised.
Yeah.
So,
But I think it's also duplicative of the other instructions about the felony convictions. Where they can still talk about the felony convictions and what they are. So I would find this to be duplicative generally. But
okay.
it is also requiring the jury to evaluate this under a different burden of proof, which would be impermissible.
Okay, you brought a negligence per se claim, right? Yes
Yes,
or
Your
no?
Honor.
Okay, so I'm gonna let you say that there was enforced at the time of occurrence of law, which read as follows. It's unlawful for any person, blah, blah, blah. You can say that his criminal conviction, you need to revise this somewhat because this isn't a situation where you're trying to prove this. He's already admitted it. So why don't you, if there isn't one in here, and there might be towards the end, I don't remember exactly, I'm sorry, I've marked a bunch of them, but I don't have clear memory of every single one of these. At least not without looking at them. Why don't you revise this in light of that?
If I can, just respond briefly, Your Honor.
Go ahead.
If you look at my instruction on page 49,
Okay,
this is, I think the instruction, the laws that I've cited in conjunction with this, if you look at NRS 41.133, it says it is conclusive evidence of all facts necessary to impose civil liability for the injury.
okay, so you're fine with this one staying as is then, because you have 49. Am I understanding you?
I'm sorry, can you say that one?
You're
more
fine with page 45, which is 4.13, saying as you have drafted it and proposed it, because you have 49.
Correct, because 49 says what has actually been violated and that pursuant to NRS 41.133, it says what NRS 41.133 dictates, which is under Nevada law, these convictions are conclusive evidence of all facts necessary to impose civil liability. Does that make sense, Your Honor?
Yeah, it makes sense to me. I understand Ms. Zena's argument, but are you?
It's
Continue.
confusing, right? You're asking one instruction, did he violate this law? And then.
But
you're
it's
telling-
suggested by them,
I know, so
And
I
it's-
mean,
and it's,
that's why I'm kind of shrugging my shoulders. It doesn't make sense to me, but that's what they want to do.
okay, so you guys are okay with this as is, then I'm gonna leave it in. 45 is gonna be in.
And I mean, just for the record, I still maintain my objection that it shouldn't come in at all, but the way it's phrased, if that's what they want, that's what they want.
Yeah, I'll join with that.
Can I just, apologize if I'm not understanding, maybe I'm just confusing myself. What was the potential confusion that Your Honor pointed out?
Okay, for me, as I read this. You've already. Like, I don't understand why this is written as it's written, even though this is the form instruction. Because of what you're not normally coming into a civil case with a conviction already on the record.
Right.
So that's why I was asking if maybe you wanted to submit a revised version of this, but Ms. Zena was saying very clearly, Ms. Zena, I believe your problem was that there's potential here that they hold him to a higher. Maybe, okay, you know what, actually, if you're okay with this, we're okay to move on, if that's what.
And I
your-
understand that, and
yours.
that's why I'm defining, I do have the additional instructions where I define beyond a reasonable doubt and preponderance of the evidence, Your Honor. So,
Okay, so this is fine, this is in as written then, if it's being suggested by it's being proposed by plaintiff, right?
yes, Your Honor.
Okay, it's being proposed by plaintiff, so as a plaintiff proposed instruction, 4.13 will come in. Okay. The next one, page 46, which I believe is NRS 48.4B653. Okay, defendant objects to this one. Does defendant still object to this one?
I'm sorry, which page are you in?
Page 46, which is another version of 4.13. It's just a different statute. This one is
Right.
48.4B653.
So
which-
same objection, just as to whether or not it should come in at all, but I don't have a problem with the language. If that's what plaintiff.
And this is the statute that he pled guilty to, Your Honor.
Okay, so this will come into. As long as it's it is consistent with 484B 653, right?
Yes, all I've
The
done
correct
is I took out the, there's lots of additional language that it completely irrelevant. So I took out the additional irrelevant language, if that makes sense.
Okay,
But I didn't add any language, if that makes sense.
okay. And your problem is you are worried that this is confusing, right, Ms. Zena?
Correct.
Okay, but it's, again, it's plaintiff proposed.
Correct.
And as the plaintiff proposed instruction, it'll come in. Because the only objection I'm hearing is from the defense is that they're worried it's gonna confuse the jury. And the jury is gonna hold the plaintiff to the higher burden of the criminal requirement, right? Am I understanding you correctly?
Correct.
Next one, page 47. There was enforced at the time of the occurrence in question a law which read, this I believe is the left turn. There was no objection to this one, right?
No objection.
Okay, so this one will come in. Okay, page 48. Defendant did object to this one, right?
I did,
So let's go over it.
and I understand, I understand the purpose for why plaintiff would want it, but I need to preserve my record on the, per se legal limit for Zaon, in a civil liability case, given that he was never convicted of this crime.
Is this actually the accurate law
Yes, Your Honor.
for somebody under 21?
For anyone.
For anyone.
Okay. Okay. So again, this is plaintiff proposed, correct?
Correct.
And your objection is because of the whole issue of the motion limiting to exclude the marijuana altogether.
Right, he wasn't indicted by the grand jury and he didn't end up being convicted of that crime. And so we would just challenge that this would be applicable in this civil litigation.
Second, I'm just making some notes for myself.
Do you need me to respond, Your Honor?
You can, but I think I already ruled the motion eliminating, so, I mean, I'm not excluding it. My only concern is what I just voiced, that there might be, I mean, because alcohol's got two standards. For when you're under 21 and when you're over 21. So is this a standard that actually applies in this situation?
Yes, Your Honor.
Because I don't want to be misstating the law to people if we can avoid it.
There are no two standards.
Okay.
At
And
least.
you know what I'm
at-
talking
at-
about?
Vaguely.
Yeah, like, at least, I mean, look, it's a while since I've been under 21. But when I took driver's ed and I was under 21, we were told very clearly that, it was 0.08 alcohol level that you could blow if you were over 21. Like the level was 0.08 and it was like 0.02 or something if you were under 21. Now I'm talking about a breathalyzer, might not equate at all, but that's why I'm just asking. I want to make sure we're reading the correct law to everybody.
I'm
Okay.
not familiar with a separate law that differentiates between under 21 and over 21 for marijuana, Your Honor. I'm very curious now. I will look to make sure. So thank you for bringing that up,
Okay,
but I'm not aware of any differences.
I don't think there was any different standard that was cited in any portion of the criminal file as well. I don't know if that's dispositive of the issue. We'll look into it.
I'm not, look, full disclosure, this is not my area of expertise. I didn't do a bunch of DUI work when I was in practice, so. And even so, the whole marijuana stuff is new because of the law changing fairly recently still. Okay, let's go over the next one. Page 49, NRS 41.133, defendant Zaon Collins pleaded guilty to the following crimes arising out of the subject collision. Is it pleaded or pled?
We
Sounds
look, we
weird.
got, we a little.
Does
we did
anybody
some
know?
research. We think it's pleaded.
Okay. So, defendant objected to this one, so let's talk about it.
I do object just, again, on on the basis that I think, given the number of instructions now regarding Zaon's violation of the law, this just gets repetitive. So, and cumulative and provides an overemphasis on this.
Well, here's the thing, in the other ones that they're proposing, they're not saying that. In the negligence per se instructions that have been proposed, and I don't think I've had alternate ones proposed. They're not saying that this violation has been proven. That's why I think we need this one.
No, I understand. I understand that. I just think that at this point, it's getting to be overemphasized with the number of instructions that were already given. And I think that we could probably, if this was condensed down, and maybe I could propose a condensed version to where it's not 5 different instructions on Zaon committing crimes.
If someone wants to propose a revised version of 4.13. Regarding 48.4, because sometimes I have seen this negligence per se instruction before given with. There wasn't force at the time of occurrence in question a law which reads as follows, and they are laws which read as follows, and people list out all the applicable laws in one instruction. And they actually oftentimes cite to the NRS, they put NRS 48.4b.600, they put the relevant part, NRS 48.4b.653, again, relevant part. Now, maybe you guys don't want that because maybe you don't want the left turn one with the other ones. Maybe you don't want them combined because there's a guilty plea, some of them and not to all of them. But that's an option, but without any alternative instruction here. And with the negligence per se instruction, what it is, which says that it doesn't say that there is a guilty plea to those. I'm gonna permit page 49 as these stand without an alternate suggestion. Is there an alternate suggestion that I missed, Ms. Zinna? Is that why you're looking through?
No, I was going to make an alternate suggestion that this language just be included at the end of, say, instruction on page 46. Because that's the reckless driving.
Well, he was also
Law.
convicted of the vehicular manslaughter, so we can't forget that one. There's 2 different ones, so.
So you would want language on both of those, or you would want those combined into one? Why don't you put it together
I'll put it together.
and propose it to them? If you guys stipulate, then we'll pull out the ones that don't need to be in here anymore and we'll put it in instead. If you guys don't stipulate, then we'll hold a little hearing on it. I'll make a ruling on that too. Okay? But for now, this one's staying in this set as it is, because I think it makes sense because of the language we left in the negligence per se ones, where we're not saying that there's any kind of guilty plea in the negligence per se instructions that come before this. I'll also note too that this again is a plaintiff proposed instruction. So it's plaintiff's choice of language here. Okay. That one's in for now. Okay, and then we get to page 50. Nevada Jury Instruction 4.4, which is the proximate cause. Do you guys want some time to review what I brought up? And we'll revisit that one later.
Yeah,
Okay.
thank you.
Just gonna put revisit in light of what I asked you guys. And specifically, I'm asking you to please review the use notes and the source and authority on jury instruction 4.4 and 4.5 in light of what you expect to present in your closing arguments as theories, because I might be misunderstanding what I expect each person to be saying in their closing argument. Okay,
Understand.
thank you. And if you need the court to print them, if you guys don't have available, just let me know and we'll print those out. Okay, next one, page 51. Defendant objected to this, which is the Nevada Jury Instruction 5.5, which I also pulled to see the language. And it was my understanding defendant was objecting because it didn't match the language of the form instruction.
Correct, Your Honor. In section 2, they added, in the pattern instruction, it says any damages for the pain, suffering, disfigurement, and loss of enjoyment of the life of the decedent, which reflects the statute. They added the words physical and mental pain and suffering, and I would just prefer that this one, reflect the statute, two, reflect the pattern, and then three, that gives to me a misstatement of the law because it does not reflect the statute.
Also a little bit worried about the use note on this one too. Okay, response from plaintiff.
My response, Your Honor, is, all this does is add in that the pain, suffering can be physical and mental. So I think, there's plenty of case law. If you look at Banks v. Sunrise Hospital case, it says, it's on page 62. Separate damages are given for mental anguish, and then it goes on. So it's not, damages aren't just physical pain and suffering, they also include mental pain and suffering. So I think that's important, and I don't think it violates the statute since Banks was a wrongful death case, being pursued under the wrongful death statute. So adding in that the pain and suffering can be both physical and mental, I think is appropriate. I think it's consistent with the law, and I think it makes sure the jury is informed of all aspects of the pain and suffering.
Which actual like subcategory here are you seeking to exclude, Miss Zinna?
So on section 2 of this jury instruction,
Sure.
take out the language physical and mental. It does not reflect the law in the state of Nevada. And speaking to the Banks versus Sunrise Hospital case, that was actually a medical malpractice action in which that discussion surrounded hedonic damages presented by an expert. As to the loss of enjoyment of life, it did not make any representation that in jury instructions, pain and suffering should be identified as both physical and mental or go down that route. They just simply discussed whether or not hedonic damages would be appropriate if they're adequately supported by expert testimony.
Okay, so you just don't want the words physical and
I
mental in
don't,
there?
yeah, because we're talking about the pain and suffering of the decedent, right? So physical
Yeah.
and mental pain and suffering of the decedent, that's not what the statute states. It would be a misstatement of the law to include that language.
Okay, and that is not on the form instruction, right, Mr. Ladah?
That's correct. I added the words physical and mental in. Those are the only words that I added in. So everything else is form, words physical and
Why do you
mental.
need that physical and mental there? Why is what's already in the form instruction not enough? With
Well-
any damages for the pain, suffering, disfigurement, and loss of enjoyment of life of the decedent.
As long as the word physical and mental is in the verdict form, I think it's enough. But if it's not in the verdict form, then I need it somewhere, Your Honor,
Why?
because I need to be able to argue that it includes mental suffering. And
Okay.
the Banks case
What
is,
precludes you from arguing that it includes mental suffering, whether or not the word's on here?
nothing precludes me from arguing, Your Honor, but I think the jury needs to see it either in a jury instruction because that's the law given to them, or on the verdict form because that's the damages they're filling in. So if they don't see it in the law or on the verdict form, they could come to the conclusion that they're not to consider it. Or they're not supposed to consider it, or the law doesn't allow them to consider it, or the law doesn't instruct them to consider it, or that the verdict form doesn't allow the category damages for them to write that in.
Okay, I'm not inclined to add the words physical and mental to the form instruction here. I'm inclined to leave the form instruction as is. So 2 should read any damages for the pain, suffering, disfigurement, and loss of enjoyment of life of the decedent. However, I want to be real clear too. I'm not at this stage limiting you from arguing physical and mental pain and suffering in your closing argument, whatever you think that was, or whatever evidence supports, okay? Does that make sense to everybody?
Understood, thank you, Your Honor.
Okay, so the words physical and mental will come off of that number 2. That was the only objection from the defendant, right?
Yes, I did not want the
Okay,
additional.
so with those changes, that's gonna come in. Let me just make a mark. Okay, next one, page 52, 5.6, plaintiff Anna Marie Echevarria is the personal representative. I didn't see any objection to that one, right?
No, I don't have, that reflects jury instruction 5.6.
So that's in. About jury instruction 12.3, page 53. If you find that the plaintiff is entitled to compensatory damages, defendant objects to the last sentence, or you want the last sentence added, that's actually part of the form instruction, right? So give me a
Right.
second to pull up the form instruction, so I'm looking at that too.
And
Go for it.
I want to withdraw my proposed instruction and agree to defendant's proposed instruction, adding the form language for the last sentence in. So in other words, I'm fine with the form language, the last sentence.
Okay, so this one will be changed, right?
Yes, Your Honor.
To defendants proposed. Miss Zena, where did you propose this?
In my, it is at page.
The objections?
This page 12 of her.
Mine was with mine. That's my competing instruction. I would just,
It's the same except for it adds the last sentence, right?
correct. It's the pattern. It's 12.3. Mine at page 12 is just the pattern for 12.3. I just want to make a record that we are still objecting to the appropriateness of punitive damages as we've stated elsewhere. But I agree that this is the proper instruction if punitive damages go to the jury for consideration.
So that will, I thought I made a ruling on the punitive damages already, did I? In this case, I don't remember. But I thought I
Well,
did.
It's something that if we decide to move for a directed verdict on, I just wanted to make sure that I'm reserving that and I'm not
Okay.
saying that I'm waiving that.
Okay. Okay, so this one will be in with the additional sentence. Because there's no objection besides defendant's objection to punitive damages generally being a part of this trial, right?
Correct.
Okay. And otherwise plaintiff's counsel, you agree to the revised version, right?
Yes, Your Honor. With the form revised version, adding in the last sentence.
Next one, the matter during instruction 1.07, page 54. You're not to discuss or consider whether or not the anybody was carrying insurance. Defendant objects to this? Or not? Plaintiff wants it in, right?
Yes, Your Honor.
Speaking for my client, I don't have an objection yet.
And I'll withdraw my objection.
Okay, so this will be it. In by stipulation. Okay. Okay, next one, how, page 55, Bautista, how any verdict you render may or may not affect the defendants in this case is immaterial. Okay, defendant objects to this, right?
Correct, Your Honor.
Okay, so here's my question from plaintiff, and I'm sorry that I don't have all of your, well, I'm not sorry, because I think it would have been really hard for me, but I don't have all of your jury instructions memorized, but how does the sympathy one not remedy the issue here? The sympathy instruction, you know what I'm talking about, that like your verdict cannot be based on sympathy. You guys have that in the set, right?
Yes, Your Honor. Sympathy is very different than collectibility. They're two completely different things, Your Honor. And I want to defer to Mr. Chu because he wrote the trial brief on this, on the
Okay.
collectibility issue.
Go for it.
But sympathy and collectibility are not interchangeable in any way, shape, or form. Go ahead.
Judge, thank you. We originally submitted this instruction timely with our at a pretrial setting because of just concerns with the party dynamics, with the defendants being individuals and not corporations. Those concerns were very much brought to life during the questioning of the jury panel during selection. And in the brief we submitted, in fairness, we submitted it at 9 this morning. But it took us a little bit to put it together.
You have the brief printed.
I do, Your Honor, and I have 2 extra copies. We did serve it and email it, but I can
You guys have a copy of the brief too, right?
approach.
I do. Do you have an extra for Brad?
I have 2 more total that can go.
Give it to them. I've got a printed copy. I just got to pull it out.
And we'll give Brad 2.
One, argue.
I have one.
Thanks.
Judge, in our brief, we list, I think, 4 or 5 examples of panelists who stated varying degrees of concern with issuing a large figure or imposing a large judgment figure against an individual. And a number of panelists expressing.
How many of those people actually are still on the panel?
Yeah, Judge, so there are a few, and I can go through it in more detail, but I think our position is regardless, these statements were made repeatedly and consistently in front of the entire panel. But there is an assortment in terms of who's on the panel versus who's off. For instance, on page 3 of our brief, juror number 800, who is on the panel and is not an alternate, said, I might differ here, but it has to be different for an individual as opposed to a corporation. An individual doesn't have the budget that a corporation does, and you're going to ruin that person completely and totally. I don't know the facts, so that's where my thoughts are going.
Okay,
And there's a number of other examples like this. And while we were sitting here, Judge, I found 3 additional examples of statements along similar lines, 2 of which are from jurists who are on our panel. And some of them are more, I guess, direct than others. But there is a major concern that we have that jurors are going to distinguish between a defendant who is a corporation versus an individual, and that will affect the number that they write in, regardless of the extent to which we meet our burdens and the evidence presented. I actually proposed a kind of a cleaner version of the same instruction, mostly because it's a little bit cumbersome. This one's worded as a footnote at the bottom of page 2. So we'd be fine if Your Honor wanted the one that we've already submitted, but we've submitted this alternative, better worded version as a.
where's the alternative?
It's the footnote at the bottom of page 2 of our trial brief. And Judge, in addition to that, we didn't come up with this out of thin air. Surprise, surprise, Nevada law is very nuanced. It doesn't address this one way or the other. But we did cite case law from a variety of jurisdictions that do talk about the fact that, for instance, quote, whether defendants are able to pay such damages is irrelevant to the determination of whether they are the appropriate remedy, unquote. That's from a New York case. There's a Florida.
So your proposal is that we give them this instruction, and then if they award for punitive, we give them an opposite instruction?
Correct, Your
during
Honor.
the punitive phase of this case?
Yes, Your Honor, changes for the second phase, because we need to make sure they don't get confused.
Okay, I'm gonna let the other side respond to this trial brief. And this one we'll put a pin into and we'll review at the end. And we'll review before we give the instructions. If you want to make additional record right now, you can. But I'm gonna give them time to respond to your brief. I don't remember all of the jury instructions or the voir dire word to word, because you guys are probably more familiar with the transcript than I am, but I thought also a lot of this line of questioning came from when they were being asked about Apple versus Samsung. And I don't know if it's fair to take their feelings about what they would do in a case Apple versus Samsung, which is very different from what we're dealing with now, and move it over into a case where we're talking about here.
So Judge, the questioning, it began in that vein. It
Sure.
shifted, I believe, after a bench conference and some objection from my friends on the other side. And the question then became something to the effect of, would you be able to award an 8-figure verdict against an individual as opposed to a corporation?
Yeah.
And what our instruction that we proposed intends to do is address both the importance of not distinguishing between individual and corporate defendants, but also to not worry about collectibility, because there were a number of statements made by panelists about, well, what's the point of going through this process if we know that the average person cannot pay anything near this amount, so it's not going to be collectible. I mean, those terms were stated verbatim during the voir dire process. And I suspect that the counterpoint may be, well, in many of these instances, the jurors ultimately stated, yes, they'd be able to follow the law, despite, saying things like, how can an individual come up with such a huge amount? It's impossible. The law on this issue is what we cited in our brief.
Yeah, but whether they think the defendant can come up with it or not, does not mean they might not still, they won't still award it.
Sure, but those statements expressed repeatedly, combined with the very unambiguous concerns expressed about if it's an individual, I have a really hard time giving that big of a judgment. But if it's a corporation, I could. This instruction intends to encompass and alleviate, I should say, both of those concerns. And we feel like it's relatively it doesn't impose prejudice on the other side, and it alleviates a very legitimate risk of prejudice against our side, and a risk that really came to pass during selection in this case. I think,
Okay.
3 or 4 panelists who are on the jury expressed these very concerns.
So you both have the daily from Wadia, right? You
We
both
do,
have the
yeah.
dailies.
We do, Judge, and we actually didn't attach it. That's my mistake. We put on file herein. I realized afterwards that the daily is not on file. So if you'd like, we can give you a copy of the transcript from which these various concerns are cited. We do have page and line numbers. You have that?
I probably need to read the whole transcript, so let me see what areas they pull up first too. Because I don't think any of these people are, I don't remember if this was brought up as a for cause issue.
I could tell you why it wasn't if you want me to, Your Honor.
Yeah, well, let me just, why don't I just read the dailies? That's
For
okay.
sure. So no, this is just for day 3 without a word index, but it is it's not a mini.
But it's in that, right?
Everything we cited, judges, in that, like I mentioned, there.
That's fine. It's a fast read.
As we were sitting here, I found 3 additional examples that I would have put in, but 2 of which are persons on the panel. We can supplement if you need to.
Okay, well, I guess make some notes for when we do oral argument on this then, after they've had a chance to respond. Do you want me to wait to see your response before I read this myself?
I would prefer that, yeah.
Okay, that's what I'll do
that's
then.
okay.
I can keep this copy.
You can, Judge.
And if I can just say briefly why they weren't for cause is because they all said they could follow the law. And this is the law across the country that damages are separate from collectibility for compensatory damages.
Okay, so here's what I'm gonna do. I'm gonna wait to read that till I see Miss Zena's response to this. Miss Zena, how long do you think you need to respond to this? Cause I know you don't really have much else going on. Totally joke, by the way.
Oh, I was like,
Not
oh,
what I'm
God.
thinking at
Can you give me till Friday?
yeah. That's not a problem. So
I just don't think
Friday-
I can get it done tonight, is my only concern.
Well, maybe Mr. Johnson can help you out, huh?
Typing out
Yeah, I
the
knew that one was.
41.410 thing, Your Honor.
He's still on 41.4.
I'm still doing math with my finger over here, so.
Trying to figure out his constitutional argument.
Right, that's typically not the hat I wear, as you can imagine.
Okay, I'm not gonna say anything. Okay. So we will, we'll hold on to this one, page 55, until I can get a response from, I'm gonna say response from defendants, because it could be from either of you. It's now Wednesday. If you think you can respond by Friday, let me take a look at how many pages this is. 258 pages. I probably need a couple hours to really actually read through that. Okay, just get it to me as soon as you can. When I get yours, I'll read it, and then I'll read this right back.
Would the court like us to email you a version of that as well? So if you want to do control F and look for individual terms and whatnot.
That might not be a bad idea. But did you give me the word index with it or no?
There is no word index.
Okay, so yeah, if you could email it to that DC-11 inbox.
All right, we'll email you versions of,
Is it small enough to email?
yeah, certainly. We'll just send you the transcripts for the first 3 days, which covered what here.
Okay, I mean, I'm not, my day, I don't think any of this was talked about.
Fair enough. Days
Okay,
2
so-
and 3.
Yeah, if you just send me the part where you guys talk, that's probably fine.
Thank you.
Okay, let's talk about the next one, 56. Nevada jury instruction 2.1. A party must persuade you by the evidence presented in court. You have a competing instruction, right, Miss Zinna? That's the issue?
Correct. And so what plaintiff did here was kind of mash together 2.1 and then 2.1A. And my preference would be do either or. Don't mash them together.
Okay, do you have any problem with her competing instruction, plaintiff?
Which pages you're competing on, Stephanie?
Or I guess competing instructions? I thought that okay, I guess 2018 splits it up, because I think 2011 used to actually have this on the same page. Or maybe it was 20, whatever the one before that was.
Yeah, the only issue, the first issue would be changing the negligent entrustment to NRS 41.440. And then
And we
Oh.
still have the proximate issue that we'll talk about, but otherwise, my pattern on page 13 is just reflective of 2.1 as opposed to 2.1A.
Let me have you guys had a chance to talk about the differences here?
No, we have not.
Okay.
We can always revisit. this
Yeah,
one.
and if you guys agree, I'll read whichever ones you guys agree to, as long as, look, if you guys have agreement with instructions, as long as the instructions you're agreeing to are consistent with Nevada law that was in place, or that applies in this case, I'm happy to read them. Let's revisit this one after you guys go over the differences and
Sure.
see if you guys have an agreement. I'm gonna put in here, council might agree. But you're out of the thing you filed today, right, Miss Cena, or you last night? At 7:56, that's where the alternative instructions are for the.
Correct.
there's very minute differences, so I honestly, I don't know that there's any objection, quite frankly, Your Honor.
I thought yours all looks like one instruction too, Miss Cena. What am I missing? Cause I'm looking at page 13 of yours. Am I looking at the wrong one? You just have what a preponderance of evidence is. They don't have that.
The only difference I see, Your Honor, is the one on 56 starts off, a party must persuade you
Right.
by the evidence presented in court that what he or she is required to prove is more likely to be true than not true. And this one says,
Plaintiff.
yeah, I like the 56 better. I think because it says more likely true than not true. I think it's more clear on what the burden is or what the
Have
standard is.
we included in here, have you included in here, sorry, what, that the additional paragraph that's on Ms. Zina's, a preponderance of evidence means such evidence as when considered and weighed against that opposed to it has more convincing force and produces in your mind a belief that what is sought to be proved is more probably true than not true. Do we have that somewhere in these already?
No, because I believe that is the exactly same as what is on the top of 56, which is to prove is more likely to be true than not true. So since it already says it there, I don't think we need to say it again in
So this doesn't use that phrase preponderance of evidence. Are we just gonna say burden then? Burden might be easier for people to understand.
well, it does say preponderance of the evidence down below. If you keep looking on 56 at line
Oh, okay, I see it.
line 8,
Eight.
for example.
Um,
I think we actually should add in, it depends how the burden of proving is affirmative events by preponderance of the evidence.
Yeah, do you guys want to talk about these two and see if you can just come up with one that you both like that incorporates everything we need from both of these? And by that, I mean, talk about page 56 of plaintiffs proposed and page 13 of defendants proposed alternatives. And let me know what you agree to, and if you can't agree, then let me know the final products you're each proposing, because I think each of these probably needs little tweaks. As they are currently, but I'd rather you guys do it than me. Okay.
Thank
Okay,
you.
so we'll come back to that. Next one, is out. We already discussed page 57 because it's a duplicate of page 44.
Understood.
Okay, page 58. If the jury determines the plaintiff is entitled to recovery, this is Nevada jury instruction 5.10. That's my understanding. There's no objection to this one, right?
Correct.
Okay, so that one's in. The next one, the loss of enjoyment of life compensate for a loss of ability to participate and derive pleasure. This is out of the bank's case, page 59, defendant objects, right?
Correct, Your Honor, because I don't believe, well, one, I don't believe the bank's case would be applicable in this action. The bank's case again dealt with the presentation of hedonic damages via expert testimony and whether or not Nevada would recognize the category of damages for hedonic damages through expert testimony. And the language that is cited here is actually pulled from, is cited too in the bank's case from the Supreme Court of South Carolina as an explanation for hedonic loss, but the Nevada Supreme Court did not indicate one way or another if they were accepting that description. Because that wasn't the issue. They were determining whether or not hedonic damages were a recoverable element underneath the umbrella of pain and suffering damages. So instructing the jury based upon a statement of a court from the Supreme Court of South Carolina that Nevada courts have not accepted in a hedonic damages case in a medical malpractice action would be so far outside the scope here, it would be a misstatement of the law.
I would disagree, Your Honor, adamantly. I believe Banks makes it clear that loss of enjoyment of life is recoverable. Loss of enjoyment of life is a component of pain and suffering. It's not something separate. It's subsumed within pain and suffering, and the jury needs to be informed that loss of enjoyment of life is something that they can consider. And I think there is, Banks clearly is a wrongful death case. I don't think it matters that it's a medical malpractice case.
Who's providing information about this? Your economists?
They're not, no, there will be no specific testimony from an expert on loss of enjoyment of life, Your Honor. There does not need to be. The case law indicates that you do not need an expert to testify on loss of enjoyment of life.
No, not expert necessarily, but where is this? What are you gonna use to argue this? Like, what did we hear?
Everything we've heard so far, Your Honor, what his life consisted of, his enjoyment with his family, discussions about his what his life was like, the things he did with his wife and his child. That's all relevant to loss of enjoyment of life, Your Honor.
Okay. Okay, you wanna say anything else?
So again, the bank's case discusses this definition within the framework of an actual hedonic damages claim that was separate and distinct from the negligence claim or the damages claim for medical recovery and everything else. And what the bank's court actually held was hedonic damages are a component of pain and suffering and may be included as an element of pain and suffering, but they did not adopt any definition. They can argue loss of enjoyment of life as an element of pain and suffering, but the jury does not need nor would it be appropriate to give them an instruction on what the expert definition of a loss of enjoyment of life would compensate for, because there is going to be no expert testimony on that. They did not hire the economist to talk about hedonic damages, and confusing them with hedonic damage definitions in the context of what they're allowed to award under the statute would be inappropriate.
what is falling under this category for the plaintiff side that you're gonna ask for? Well, I mean, I'm not sure I quite understand what you're, like, why you want this in and what you're asking for with this.
Well, the first thing, Your Honor, I want to point out is the standard jury instruction. Nevada JI 5.5 that defense counsels agreed to. The one that I added in the words physical and mental, and the court has ruled physical and mental should be removed.
Yeah,
That standard jury instruction actually mentions loss of enjoyment of life. It says
Okay.
any damages, and this is the standard instruction, not the one I added the words
I'm
into.
gonna pull it up.
Any damages
What,
for,
remember what page that was?
yeah, this is 51 of plaintiffs,
Okay.
or we can look at defendants.
No, I got it. Okay,
If you
so
want to look at defendants, so it's the one that's not changed.
number
it's
2,
pa-
any damages for the pain, suffering, disfigurement, and loss of enjoyment of life of the decedent.
Correct,
Okay,
and
and
that's
so
not-
you want this to define loss of enjoyment of life?
Correct, we need to define what it is, Your Honor. And I think this is a definition right out of the Banks case. It's comes right from Banks.
So again, this was not held to be the definition in the context of the wrongful death statute. So jury instruction 5.5 is a recitation of the damages that are allowed per statute. And we have to be careful here, right? Because the damages awarded are allowed per statute for a wrongful death claim are a little bit narrower than a general negligence claim. So this jury instruction does not define enjoyment of life. There is no case that says the loss of enjoyment of life is defined as such and such in the context of NRS 48. What is it? 035. 48, whatever, of what the wrongful death statute, excuse me. And again, the Banks case is not talking about damages that are allowed under the wrongful death statute. The Banks case discusses hedonic damages as a category of damages pursued by an expert or supported by expert testimony. So the Banks case does not support this as being an element or a definition of damages for the wrongful death statute. I think that because the wrongful death action is a statutory creature, we have to stick with the language of the statute and we cannot go beyond it. And if the framers chose not to define loss of enjoyment of life and leave it up to the people's common sense, then that's what the framers intended to do. And there is no jury instruction that complements or supports plaintiff's position other than the mention of it in the pattern instruction that mimics the statute.
Your Honor, can I clarify something?
Sure, I'm looking at page 51 as you guys are talking, but I'm listening to you. Go
Is-
for it.
The truth is, as long as I'm not going to be precluded from arguing loss of enjoyment of life, because it's in the standard jury instruction, the defense counsel has already mentioned, or already agreed to, already stipulated to. So as long as I'm not going to be precluded somehow from arguing it, in theory, I guess I don't need a definition of loss of enjoyment of life. That's her objection. That would mean that I can define it however I want, technically, or I could tell them to use their common sense, and which is another standard jury instruction, and use their common sense, decide what a loss of enjoyment of life is. So if that's her objection, then as long as we're going to use the standard jury instruction for the damages that was in, I think, page 13 of defendants,
51 is the one coming off of the.
51 for loss of enjoyment of life. For the standard instruction, then I have no problem under those circumstances waiving the definition of loss of enjoyment of life, as long as I'm allowed to say this is what loss of enjoyment of life is based on your common sense. If that makes sense.
My only objection to that would be, of course, I don't know what counsel's going to say, if it seems like he is giving them a legal instruction on what it is and defining it for them versus explaining what he believes they should be considering. I think that would just be handled via objection, and that would be my only issue with that. If
Okay.
he essentially reads the Banks case to them, that's a problem.
Well, I wouldn't be planning on reading the Banks case. I would just tell them to use their common sense and talk about what is common sense that you enjoy in life, that's the component of enjoyment of life, if that makes sense. So as long as I'm not gonna be precluded from doing that, I don't need the definition. that makes sense, Your Honor.
I'm not gonna preclude you from saying you can use your common sense to. If that's what it says, you get to use your common sense. To determine what this is. I don't know if there's gonna be objection or not, but I'm also not gonna give you speculative ruling, because I don't know exactly what's gonna come out of your mouth, but. I think everybody's free to say you can use your common sense when you determine what. Loss of enjoyment of life means. Can use your common sense when you determine what's reasonable for pain and suffering, all of that. So with that being said, you don't need this then, right?
Yes, Your Honor, I don't need the definition.
Okay. I'm gonna exclude it then. This is out. With the understanding, no one's waiving objections here, but we are gonna let arguments based on common sense. We are gonna permit that, and you get. Page 51 is gonna come in where you get to go through the different things that they can award. Okay. 60, an award of suffering may compensate an injured person for shock, fright, emotional upset, or humiliation as a result of the defendant's negligence. In addition to pain, suffering, loss of enjoyment. Is this objection the same, counsel?
Slightly, but yes, the Banks case simply, again, does not apply to this action. This was in the same vein of talking about whether or not hedonic damages are a compensable element. And this language actually came from, again, the Supreme Court of South Carolina statement. And the full quote is, separate damages are given for mental anguish where the evidence shows, for example, that the injured person suffered shock, fright, emotional upset, and or humiliation as a result of the defendant's negligence. That is not a holding of the Banks case. It was provided, they cited to the Supreme Court of South Carolina. They made no indication they agreed with that. That is not a statement of Nevada law. And then the second objection to this is we don't have any competent evidence to show that the decedent suffered shock, fright, emotional upset, or humiliation as a result of the negligence. The doctor stated perhaps he could have maybe had pain and suffering, but we don't really know. But there is a study out there that shows that. And that is the only testimony that we've had from any sort of qualified medical professional that Mr. Echevarria suffered any shock, fright, emotional upset, or humiliation. And we don't unfortunately have Mr. Echevarria here to testify to that for himself. And I think that using these words, when we're talking about other instructions, they can compensate for pain and suffering. We have a lot of instruction on what they can award. This also gets repetitive, cumulative, overly prejudicial.
My response, Your Honor, if I may. So first of all, this language from Banks is not taken from another case. This is not part of the block quote. So there is a section where Banks block quotes language from a different case.
Let me
This is-
start with this, actually, because maybe this sums it up. I'm not gonna preclude you from saying you can use your common sense. I understand Miss Zina's argument of, at least I think I do, well, we don't know if he was actually feeling anything. I think you're referencing like when he was probably, I don't want to say stuck, but that might be the best term for it, like when he was jammed between the wall and his vehicle. But I think we can assume fairly without, or actually, I think we can use our common sense that he saw the vehicle coming at him at some point. And when he turned, so is that what you plan on arguing here?
Yes, Your Honor. And I believe there will be testimony from the officer that was in his report when he testifies today on that.
On what, when he would have seen this vehicle or something else?
Yes, he believes, he
Now,
gave,
why do you need me to say this, though, I guess is my question. Are you just looking, are you worried that they're gonna say you're precluded from asking for damages for shock, fright, emotional upset, or humiliation?
no, I'm worried because this is not defined anywhere. So at least the loss of enjoyment of life is actually in the standard instruction. This is not in an instruction anywhere. So,
Yeah, but come on, you really think like a jury needs a definition of suffering from me? I'm not saying that you're not gonna be able to make some of this argument if evidence supports what you're gonna argue. But, I don't know if we need to give people a definition of suffering.
Well, I do believe this is separate because it says separate damages are given for mental anguish. Where the evidence shows, for example, that the injured person suffered shock, fright, emotional upset,
51.
and or humiliation as a result of the defendant's negligence. I'm reading that directly from the Banks case, page 62 of Banks. And it is not quoting from some different jurisdiction. This is, language from our Nevada Supreme Court directly. So I think this is important because it's not subsumed within the instructions on pain and suffering or loss of enjoyment of life. It's not subsumed within anything in the verdict form. The jury needs to understand that they can give damages for these specific things.
All right, I'm gonna let you talk in a second. Are you trying to define suffering for everybody here or just for the decedent?
This just includes the decedent.
Okay. Okay, go ahead, defense counsel.
Okay, once again, the wrongful death statute is a statutory creation. The remedies are limited. The terms and the categories of damages contained within that statute are not either defined in that statute framework, nor are they defined in the jury instructions. So pulling from a different case with different circumstances and different laws is not appropriate to define those terms. I don't think, and I don't want to quarrel with counsel. I am not seeing it said anywhere else besides at page 836 and then page 62 if we're looking at the P3D marker. And that's a quote from the Supreme Court of South Carolina. But if you could provide me with a different citation.
Well, I can show you what I'm looking at. This is the block code here. This is not a quote.
You know, they're two block. It's this. These are the block because they're both indented.
Okay,
So regardless,
this one, here's the thing. I know both your arguments right now. I'm gonna review Banks. I'll get back to you on this one, okay?
thank you.
I'm not trying to rush anybody at this point, but at the same time, I want to give my staff an hour if I can before they have to be back in here.
Understood.
So I'll review Banks. We'll revisit this one later. I'm marking it to revisit.
Thank you.
Okay, last one, page 61. Jury instruction 2.4. I know there might be more, but we'll revisit some of the other ones later if we did, or we'll get to some of the other ones later if we didn't get to them today. Where relevant evidence which would properly be a part of this litigation is within the control of one party. So I guess, I'm sorry, my memory is not great on everything because I have 1,000 cases right now. Did we have motion practice in this case where you got this instruction
Yes, Your Honor, there was a spoliation motion that was granted by Your Honor.
for the vehicle?
Correct. There's an order
Okay.
on that.
So.
So I
defense.
object, I maintain my objection and preserve it for the appeal because I don't think that that was an appropriate remedy in this case. So I object to this instruction on that basis.
Here's my question though. We had the accident recon guy up here, right? Did he say that failure to preserve the vehicle affected his conclusions in any way? Like if he had had the vehicle, he would have been determined X, like what hasn't been able to be determined because of the vehicle? Because the accident recon guy seemed to very clearly be able to assess fault and assess the facts of the accident without this.
He-
So what, I mean, this just creates a question mark.
He didn't say one way or another, Your Honor. But
But
this
he
was.
didn't say one way or the other
No, he did not
about
say
the
one way-
vehicle.
About the vehicle.
Okay.
But this is based on the order of the court. Defense counsel did not file any motion for reconsideration. And I think we're entitled to this based on the ruling from the court and the motion practice earlier in the case. And we specifically filed this early on for a good reason, Your Honor.
No, I mean, I understand why you would file it, but what I'm asking is, what conclusions are you gonna ask them to make with this? That are supported by any evidence we've had so far at the trial? Now, maybe the detective's gonna say something, I don't know. But, so, I mean, I'm fine with just reviewing this one later, but I'm just giving everybody a heads up to where I'm leaning with this. I get, and if you're telling me, I will go back and look to make sure, but if you're telling me that I made this ruling earlier, I probably did make this ruling earlier if you didn't have access to the vehicle, because that ruling would make sense. But at the same time, if that were the facts, but at the same time, I haven't heard anybody take the stand here to say you can conclude X, or we would have been able to assess X, Y, or Z if we'd had the vehicle. And if we don't have that, then I don't know what you use this for, other than to ask the jury to say something that we don't have anybody saying they could assess.
I don't think we need to have an expert or anyone testify to that, Your Honor. That's the point of not preserving evidence.
No, but what I'm asking you is, what are you gonna ask the jury to conclude as a result of this?
There could be a number of things, and it depends on what defense argues in their closing. But one, for example, would be, well, could we have tested for marijuana other places in the car? There's a lot of different things that we could have tested the car for, or our experts could have done an inspection of the car and looked for. And the point is, evidence has to be preserved. Failure to preserve it results in spoliation. It's not a rebuttal presumption, it's adverse inference, Your Honor. Because it's negligent, failure to preserve, not intentional spoliation.
Okay, you guys wanna say anything else on this?
Your Honor,
I'm gonna wait on
clearly
this
sees the
one.
issue here. There is no, the expert did not testify in any way, shape, or form that the loss or the inability to inspect the vehicle and have inhibited his inspection of, or his reconstruction analysis in any way. The police officer clearly would not have that problem since he inspected the scene when the car was there. So without that evidence, we believe that the spoliation instruction is inappropriate, as we had originally briefed in the opposition.
Our position is, Your Honor, the motion for basically, what was the caption? Was it something for a jury instruction?
Adverse inference.
And that, yeah, but you have to look at what the motion was. It's going to have to follow the facts that's presented at trial for that to go to the jury, and they didn't present those facts.
Okay, we're gonna revisit this one.
Okay.
After we hear all of the witnesses take the stand.
Thank you.
Because I don't know what this is gonna be used to ask the jury to infer. And because like I said, I'm not hearing anything. I'm not hearing how having the vehicle would have allowed any other conclusions than what we're coming to. And honestly, I'm trying to think about the conclusions, but let's see what the officer says. Okay. Any other ones, we're not gonna make a record of now because I'm gonna give my staff an hour for lunch, but any other ones that we need to go over that are part of the proposed set? I know, Ms. Zinna, you had other ones attached here.
And so did plaintiff, so we'll probably need to there's only a handful left. But
Okay,
I would like to maybe just have a day before we do that, and maybe council and I can chat some of these out before we
Okay.
come back.
can somebody send me these in Word? And I
Yes.
will put them together based on my rulings of these so far. So
Yes.
we have one set to work from as a master set going forward. And then I'm holding up the other ones that I got. Any additional ones we can think of it. I'm gonna leave these in the order they're in right now, just so that it's not confusing to anybody. So when you look at what I put together, you can compare it to what you believe were the rulings. And then if there's any problem, we can discuss that too when we next meet to discuss this. I don't know when we're gonna next meet to discuss this, but we'll find time in one of the mornings probably.
And just to be clear, I think there were 3 other filings, 1 late last night and 2 this morning. You do have those, I'm assuming.
I did get 3 other filings from plaintiff is what you're saying?
Yes.
I got a 5/14, 8:58 AM. I got a 5/13, 8:11 PM. Those were verdict forms. I got a 5/13, 6:32 PM. I got a 5/13, another 6:32 PM, 5/13, 8:48 PM.
Yes, that's
Do
all.
I have them all?
Yes, thank you.
Okay. Okay, and you can send me these in Word, is it Mr. Chu, you have it?
Paralegal can do it right now.
Okay, thank you. Please send them in Word and I will put together a set with just what we've done so far, with the understanding that there might be more in what I had submitted to me last night and this morning that we still have to review. Okay,
Thank you.
anything
Okay.
else? Thanks. I'll see everybody at what did I tell the jury? 1:15? 1 o'clock. I'll see you guys at 1 o'clock.
Thank you.
Thanks.
Good.